Okay. This is a meeting of the Government Operations Subcommittee of the Health and Government Operations Subcommittee. We have two bills on our agenda today. First is House Bill 389, Procurement, Minority Business Enterprises Revisions, Delegate Wilson, and then HB 375, Open Meetings Act, the Maryland State Agency Transparency Act of 2022, Delegate Corman. Council Lindsay, can you bring us up to date on what we've done thus far with regard to House Bill 389, please?
Sure. House Bill 389 is the bill that implements the recommendations from the Department of Legislative Services evaluation of the Minority Business Enterprise Program. Last week, we discussed what the recommendations were and some feedback from MDOT and GOSBA on those statutory recommendations. I circulated an amendment on Monday, I believe, that makes several changes to the bill based on the recommendations from MDOT and GOSBA. I had a meeting with them on Friday, and so they've approved these recommendations. I understand DGS has also joined the call today because they have some feedback on one of the changes made by the amendments. And then Michael Rubenstein from DLS is also on the call now. He gave the presentation on the DLS report during an early session briefing, so he's available to answer questions, and I believe also has some information about some of the priorities that the Senate is pursuing with regard to this bill. So going through the amendments, they sent around a reprint of the bill, so I'll refer to the page numbers in the reprint. The first change appears on, or I'm going through in the order of the recommendations, not necessarily the order of the bill. The first recommendation change was from MDOT. It appears on page 11 of the reprint. This is to include the names of each prime contractor and each subcontractor in the compliance assessment rather than in each minority business. And the second change appears on page 12 of the bill. This is the original recommendation was to require.
Let's see if we can just get approval on each one. Yes, okay. I think that would be helpful. So the change on page 11.
It's in line 8. It takes out minority business.
Oh,
it requires.
I was looking for it. Okay, thank you. So this is supported by whom?
That was a suggestion made by MDOT.
Okay. No objections? It is approved. Okay.
All right, the next thing I'm going to highlight
is. If there are people in the audience who have issues, please let it be known before we say yes, before we approve something. Okay, Lindsay, sorry.
The second change I'm going to highlight appears on page 12 of the bill. This is the original recommendation was for GOSBA to publish a list of prime contractors who persistently fail to meet MBE participation goals in the absence of mitigating factors. There was no specific language discussed at last week's meeting. This change came out of the meeting that I had on Friday with MDOT and GOSBA. The suggested change, appears starting in line 22 on page 12, which is rather than GOSBA developing the list, it requires the Office of State Procurement in the Department of General Services in consultation with the Office of the Attorney General to develop criteria used to determine that a prime contractor has persistently failed to meet contract goals in the absence of mitigating factors. It requires, as part of the criteria, that the Office of State Procurement should include the results of the compliance assessments, and then the Office of State Procurement shall maintain a list of prime contractors identified using that criteria for use by procurement officers to determine whether a person is a responsible bidder or offerer rather than publishing this list on someone's website. And this is the recommendation that I believe DGS is here to discuss.
Okay, Mr. Hafley?
Can I ask a question about that language?
Sure. Sorry, go ahead.
As Lindsay read further, I see it in front of me, number 4, feeling a little more comfortable. Determining whether a person is a responsible bidder or offerer. I don't know if it seems strong enough to suggest that if someone is a repeat without, in the absence of mitigating factors, that they shouldn't be getting future contracts. So should that language be stronger is what I'm wondering.
I mean, I'll speak on behalf of GOSBA. I'm Chantel Kailouis, Director of Policy at GOSBA. And we understood the concern regarding identifying prime contractors who consistently fail to meet MBE goals. And the purpose of this provision, we believed, was to ensure that those vendors do not continue to be awarded prime contracts. Hence why we recommended that perhaps this should be housed under DGS and OSP as the overarching body for state procurement, who are responsible for reviewing and awarding contracts. We're amenable to stronger language, but we do believe that many of these contracts come across OSP's desk. And so it would make sense to have that list internally available to the procurement officers in order to make a determination as to whether they should award to a vendor who has not met that criteria.
Thank you. That as you describe it, it sounds strong enough to me. Thank you.
Does someone who makes this list, do they have any, I don't know that it's a right of appeal, but what ability do they have to challenge the information that's on this list?
Yeah, Delegate, that's one of our prime concerns. There's no due process here. If they're going to be not allowed to have future state contracts based on some recommendation, I think there probably has to be some process through which they can appeal, to your point.
Is there precedent or some procedure that in existing law or regulations that would provide for the method of appeal?
I guess today,
Oh, God, I'm sorry. Go ahead, Mike.
no, sir. I was just going to say, I guess today, if a bidder or offerer is determined not responsible or responsive, they can protest or appeal to the agency and then onto the Board of Contract Appeals. That's the process today. It's not clear to me that being put on a list, I mean, assuming you can protest anything, maybe it does meet the criteria, but that's one concern I had, the apparent lack of due process.
If I may, Mr. Chairman.
Certainly, Mr. Rubenstein.
Michael Rubenstein with DLS, one of the authors of the report. This is consistent. The point that Mr. Hafley's bringing up is consistent with our thinking when we developed this recommendation. We did anticipate that there would need to be some sort of due process and some sort of a right to appeal once a designation was made that the firm should be on the list. We're comfortable with that kind of language if that's the committee's desire. There should be due process. There should be a right to appeal, and that would be consistent. We did anticipate, or we did think about the option of just having these vendors debarred, which would completely prevent them from participating in state procurement. We thought that was a little strict, a little harsh. So we think this still accomplishes the goal without being quite so harsh. But still prevents them from getting new contracts as
Could I ask the three of you, the two Mikes and Lindsay Rowe, you're now speakers if you're the two Mikes, to see if you can come up with due process language that would address the due process problem.
Yeah, I think in the original recommendation, we just had GOSBA developing regulations that would include that due process. So we can include that or something similar in this language too.
I think the purpose of the amendment adding the OAG's office was to provide weigh-in from a legal standpoint as to what would be appropriate due process.
I would prefer if we have some language from existing law that explicitly provides for the due process. I think that's what we should shoot for. Delegate Johnson.
Thank you, Mr. Chairman. The question is for Mr. Rubenstein. What is the difference in debarred and not getting any new contracts?
It's in some ways a little bit semantic, but debarred is you go through a hearing process. You are barred potentially not only from doing business with the state, but also potentially with other local governments in the state, other entities. This just seemed more of a softer approach that would enable them to, come off the list at some point and participate in future contracts if they can demonstrate, or a certain amount of time has passed, or they can demonstrate that they've reformed their ways. It just seemed a little less definitive.
All right, thank you. Thank you, Mr. Chairman.
Certainly. Delegate Hill.
Thank you, Mr. Chairman. So I know that under the statute that references debarment, there is language about appeal process. And so I was just going to ask Lindsay off the top of her head, does she think that that may be where we need to just draw that appeal process from? I think it includes the Office of the Administrative Law Judge. I think actually the debarment includes the Board of Public Works. And there may also be a court piece. And I know they can take time to do that, but I was just asking, I wanted to ask Lindsay if she knows if that may be where we can get that information or that language.
I think that process is a lot more involved because the process of being debarred is a little bit more onerous as far as like the process for getting debarred in the first place is more onerous. So the process for appealing it is as well. I think what would probably make sense is for the Office of State Procurement to come up with whatever the appropriate appeals process would be from their perspective, as far as either getting removed from the list or appealing the decision in the first place to have been put on the list, whether that's appealing having been placed on the list or appealing your continued presence on the list because you've reformed in some way. So it would be, I think, two different approaches to getting off of the list.
Thank you.
Okay, so I think you know what we're trying to accomplish here, staff, Kent, Lindsay, and Mr. Hayfley and Mr. Rubenstein, so we'll move on.
The next recommendation that was addressed through amendments was the repeal of the authorization to assess liquidated damages. That language appeared on page 8 of the bill, so it is struck now, beginning on page 8. The responses that we received related to this was first that GOSBA suggested training of agencies by the ombudsman. So that language appears on page 17 of the bill. Under the requirements for the ombudsman, it starts below line 15. The ombudsman should conduct trainings for procurement officers and units of state government on enforcement of the requirements of Title 14, Subtitle 3, that's the MBE program, of including the assessment of liquidated damages. Relatedly, on this, MDOT had also suggested maybe the possibility of doing a study. So the subcommittee suggested adding study language that appears in a special section, which is now newly added on page 18 of the bill. During discussions last week, we discussed several studies that would be taking place or reports back to the General Assembly. The first appears in special section 2. That one is requiring the ombudsman to report back on the staffing levels of the office. This section 3 is the one on reporting back relating to the use of liquidated damages. When we had discussions last week, we talked about having both of these reports due December 1st, 2023. I ended up staggering this one, so that is open for discussion, but I staggered it to June 1st, 2024 to give the ombudsman an opportunity to report back on their staffing levels, and also because the bill itself goes into effect July 1st, 2022, the ombudsman isn't going to be in existence as soon as the bill goes into effect. They won't have their staff, so it gives them an opportunity to actually get up and running, start conducting these trainings, and then once the trainings have been up and running for some period of time, then this report back could happen on whether or not there's been any change to the use of liquidated damages. So that was my thinking on that. Obviously the subcommittee can change that date or change the nature of that report back to the General Assembly. And then while we're on the subject of the reports back, I also have special section 4 here, which is the Department of Legislative Services reporting back on the implementation of these recommendations. And that report is due back December 1st, 2024. That wasn't in response to any of the specific recommendations from the report, but based on the discussions from last week.
DLS usually is not on the receiving end of codified language. You're usually drafting. Okay. Any comments?
Yes, sir. If I could just make a general statement. I'm a little bit concerned about the scope of the ombudsman's duties. I think the procurement officer has to be a part of discussions, resolving disputes. Ultimately, or at least today anyway, they're typically the ones who make final decisions about contracts. So I'm a little concerned about each of us staying in our appropriate lane. I don't have a suggestion for that, but I just want to raise that concern, especially, again, I have a due process question as it relates to ordering payments to be made from the prime to the sub. And as it relates to the dispute resolution. So I understand the general intent of this. I think that's fine. I'm just a little bit concerned as we dig down into the weeds that there's that the procurement officers involved and back to due process. I'm not sure what that looks like. Again, if that's Board of Contract Appeals, or maybe we have the same discussion about this as we do the other.
I can address some of the intent here.
Certainly. Mr. Rubenstein, followed by Delegate Hill.
Certainly, the intent is, we heard from a number of MBEs, both in the focus groups and the surveys that we did, that they didn't know where to go when they had a dispute with their prime contractor. And we wanted to provide them with a single point of contact. But at the same time, we do not anticipate that the ombudsman would be able to resolve every dispute that came to it. And so we did include some language in the recommendation. I believe it's also in the bill, that basically the ombudsman would also help agencies resolve disputes that came to them and or refer things to them as appropriate. So we do anticipate that there would be a collaborative effort between the ombudsman and the individual agencies. If there needs to be some clarifying language, I think that's perfectly fine. But I think our intent is not necessarily counter to what Mr. Hafley is raising.
I was just going to say, could there come up with clarifying language? I think that would be helpful. Delegate Hill.
Oh, sorry.
Oh, Ms. Lewis. Hi, Lewis.
I would also point out that there are MBE liaisons in place at every state unit who are there to essentially serve as a voice for the MBEs facing issues on contracts. And so that is typically their point of contact. So if there's a way that we can align the ombudsman's process or contact with the MBE liaisons, that would probably be beneficial.
Yeah, and what we heard from MBEs was often that they would go to their liaisons and the liaisons couldn't do anything because they didn't have a contractual relationship with the agency. And so, we wanted to provide another avenue for them to go and be heard and possibly have somebody be able to step in and resolve any disputes that did come up and have that authority to do that. So that was the thinking and that. But again, we can certainly come up with clarifying language to increase that collaboration between the agency folks and
So the three of you will work on that.
Sure.
Delegate Hill, please. Thank you. Delegate Hill.
Yeah, they're going to work on it. So maybe I can just not. My concern, what I was hearing on the one hand was we've got a procurement officer who ought to make these ultimate decisions. We've got an ombudsman who, at least is written here, is really seen, it seems to me, as the ultimate mediator, right? Who's mediating these issues and coming up with a decision that's sort of a binding mediation. And that's what I think Mr. Hafley had an issue with. But I think with Mr. Rubens, unless I'm misunderstanding exactly what they wanted, because the liaisons are not doing that job and it's not very helpful. So I think you have to resolve or I think we have to resolve as a committee, do we want the ombudsman to be, the oversight person of disputes who resolves the disputes, or that on section 2, lines 21 to 22 of page 17, whether instead of ordering a relevant payment, we want them to just recommend it. But then that still gets to, well, then who gets that final decision? And I think that's ultimately what we're talking about here. Who gets the final decision in the disputes? And this suggestion should be the ombudsman. And I think what I'm hearing is people aren't comfortable with that. So I just was wondering, Mr. Chair, if I'm right in my assessment of this discussion.
I think actually you are, because I think that was sort of our thinking, where if somebody goes to the ombudsman first, they would probably be referred back to the agency or the MBE liaison to see if they can resolve the issue at the agency level. And then if not, it would then rise back up to the ombudsman to see if there's something they could do with a little bit more authority than the agencies have currently. So I think that's our thinking, is that they would sort of be the final arbiter if it couldn't be resolved at the agency level. And we can clarify that in the bill if that's necessary, but I think that was our thinking.
And I think that's the issue that the other folks have. So you said you have an issue with their authority. So who do you think should be the ultimate determinant if in a case, Mr. Hafley?
Yeah, thank you. I think my point was that it shouldn't be done in a vacuum. There should be collaboration. The other thing I would say today, only the procurement officer is authorized to take contract actions. We can certainly change that. But again, I just wanted there to be a collaboration, coordination of the effort. That was my point.
Well, I hope that the three of you can come up with such language, and I would ask you to share it with Delegate Hill as well as to myself and committee counsel before our next meeting. Okay. Next, Lindsay.
The next recommendation that is reflected in amendments was codifying the executive order requiring mid-sized procurements to be set aside for small businesses by designation in the Small Business Reserve Program. MDOT had suggested allowing MBEs, DBEs, and SBEs to participate in the Small Business Reserve without any special separate registration process. This appears on page 12 on the bill. Let me look for the line number, sorry. Oh, this is because of the change in the pagination, if you will, based on the amendments. It starts on the bottom of page 12 and gets pushed onto the following unnumbered page. So the page that appears between pages 12 and 13
Sure.
of the bill. So again, this just allows them to be certified without the need for any to file any other additional paperwork other than evidence.
And if I may, I guess I just had a question here. What about the existing size standards? Would they apply? Or is this notwithstanding the other requirements for SBR?
I believe MDOT's testimony, and they are here that they can speak to this, but they felt that they already met these requirements due to their certification as an MBE, certification as DBE, or qualification under the SBE program.
Okay.
This is Sabrina, MDOT OMBE. Lindsay, and further looking at that, we may need to walk that back because our size standards are significantly larger than the SBR program. They meet small business requirements under the state and federal programs, but our size standards, for example, for an industry might be 8 million to 16 million, where theirs is 4 million, something like that. Some of them have requirements of the number of employees, like 50 or 100. Ours runs 100 to like 1,500. So that's a significant difference in the size standards. Although the MBEs and DBEs and SBEs are classified as small businesses in the certification program, but significantly higher size standards than the SBR program. So I just wanted to interject that.
So is MDOT no longer making this recommendation for this amendment, or are you suggesting a change to the amendment?
Not making that recommendation at this time. There'd have to be some significant changes in order to try to do that, what we were trying to do. We just wanted to try to add more businesses to the SBR program. But like I said, their program is so much smaller. The requirements are so much lower.
And I would just add, I think, you know, I asked a question for clarification. If the size standards apply, then I think that'd be great.
Lindsay, can I get this?
Oh,
is Fuller.
that's how
sorry.
it works under current law. If the size standards apply, they can still apply to be an SBR, but they would need to provide further documentation or fill out the form, the self-certifying form. So it wouldn't be that automatic translation that this provision was previously suggesting.
Okay. I would like to ask the parties involved to see if you can reach a consensus on this point and report back to council and myself.
Yeah, this is not an issue that we directly addressed in the report. And the main reason for that is that, as was pointed out, the SBR certification process is self-certification. It can be done fairly quickly and often happens when folks register for the Maryland Marketplace. And so we didn't think there were really any significant barriers to participation as an SBR. And so we thought, you know, once this codification takes place and MBE started to see that they would have access to these set-asides, there would be a more of a rush to do that self-certification. And we just didn't think that it needed to be addressed because it's such an easy process.
All right. Well, you can be part of those discussions.
Yep.
Okay.
Mr. Chair.
Delegate Hill.
Again, thank you. I'm trying to see if I'm understanding. I think that the question was, do the size specifications apply? And the answer I heard is they can apply, they should apply, and that won't change what we're trying to do here, and that there's no objection to their applying. So I guess that's the question. Does anyone object to saying, yes, the size specifications that differentiate between these three different groups would apply here too, but they would still be included on the list with the appropriate size specifications? I don't think there's an objection to that.
No, but that's already the practice and it's already cited in regulation. So this would be duplicative if we were to.
Yeah. Mr. Rubenstein, you have no problem with that. And so Mr. Hafler just wanted to know. So I think this is actually resolved. We just want to clarify that they still apply.
I agree with that.
Thank you. Thank you very much, Delegate. Okay, Lindsay.
The next recommendation we discussed is the report from the ombudsman on their staffing levels, which appears on page 18 of the report. On page 4 of the amendments, the report recommended to have
You
GOSBA.
mean page 4 of the amended bill?
Yes, I'm sorry.
Okay, fine.
Of page 4 of the reprint.
Right.
The report recommended requiring GOSBA to establish statewide goals by industry type. We received feedback from both MDOT and GOSBA on concern about having this by industry type instead. And MDOT had suggested that industry type instead be the procurement category. So that's what you see beginning underneath line 28 on page 4 is definition of industry type.
And I can just jump in and say that was always our intent. It was just a different terminology that we were using. It was always our intent to use these classifications, so we don't have a problem with that. While we're on this subject, though, there were other issues raised, I believe, by the Attorney General's office and maybe either MDOT or GOSBA about these industry type goals. And as we indicated, the purpose here is to increase transparency for the agencies and to essentially do the reporting by these industry types or procurement categories, whatever you want to call them. Because, if you're an agency, the participation levels for services, for instance, are about 13%. Participation levels for commodities are around 7% based on the most recent data. For construction, it's over 30%. So if you're an agency that does services and commodities, you're not going to be able to hit 29%, but that's what the reporting is holding you to. And so if we want to take this out and the concerns raised by the Attorney General's office with this would have unintended consequences of possibly excluding some groups from some procurements, and we don't want to do that. So we want to be sensitive to that. So we can take out this whole recommendation for the industry type goal setting, but move it to the reporting process and then have GOSBA report agency performance by these procurement categories. And I think that would still get at what we were trying to accomplish with this recommendation.
What is the Attorney General's concern?
100% agreement.
The Attorney General, as it was communicated to me when I discussed it with them, was that having industry goals would have the unintended consequence of excluding certain groups that maybe didn't meet the.
For whom there were not any goals.
Yeah. I'm sorry?
For whom who weren't included
Right.
in the list.
Right. And so it would possibly exclude certain groups from participating in some procurements. And what they said is this is why they do the sub goals, because that sort of addresses that issue. So we're comfortable if wants to take out that recommendation to have the goals set by industry type or by procurement category and just do the reporting by them at the agency level.
And is the Attorney General satisfied with that?
Yes, I'll speak. I don't believe they're on, but I'll speak on behalf because I did have a long conversation with the OAG's office yesterday. We are in 100% support of those amendments, both COSPA and MDOT. We think it'd be beneficial for agencies to provide some type of MBE, maybe shortfall analysis that gives us a clearer picture on where they are meeting goals versus where they are not, and what the reason may be, as opposed to an oversweep of how we actually set goals.
Delegate Hill.
Thank you. I wanted to ask Lindsay if we move that, does that meet DSL's concern? Because my understanding is in this section, it's about the summary of the factors used to determine the expected degree of participation, not necessarily if the report is about that they meet those degrees. This section is about how did you determine what that amount of participation should be. So if we take that recommendation, does that meet the recommendations of the report from DSL's standpoint, DLS's standpoint, sorry.
These are actually two separate recommendations. I think what you're referring to is the language that appears at the top of page 4, and it actually appears in a few places in the bill about including a summary of factors used to determine the expected degree of minority business participation. That language is actually the one I was just going to get to next, is still in the bill. After discussions with GOSBA, who had raised a concern about that language, they decided that that was fine. The question here is about having goals by industry type, and rather than establishing separate goals by industry type, this would just be having GOSBA have the reports list whether or not the goals are being met by industry type. So it's not that a separate goal is being established, but it's parsing the existing goal, if you will.
And consistent with the recommendation.
Yes.
Good, thank you.
Okay, next.
So as I just mentioned, the next one that I was going to get to is that including the summary of factors used to determine the expected degree of participation. That language, after discussion with GOSBA, is left in the bill. No change and no amendment is made here. The last recommendation was about allowing graduated MBEs to maintain their certification if they participate in the mentorship program. Both MDOT and GOSBA suggested striking that from the bill. So that language is struck on pages 4, 10, and 18. And that's the last change from the amendments.
And is there consensus that it should be struck? There appears to be no objection to striking.
Mr. Chairman, if I may, I did have a conversation with Senator Griffith a day or two ago. As you know, the Senate is considering the same bill. And she had authorized me to convey some of the things the Senate is thinking about. And this is one of the points that the Senate is thinking about. I don't think there's an objection to deleting this language, but there is a strong interest, I think, in the Senate, which I think you raised during one of the hearings or one of the work sessions, about trying to create incentives for experienced MBEs to mentor incoming and younger MBEs. And there's a strong sense in the Senate that they want to try to find some kind of incentive. This was our effort to provide that incentive, and it may not be feasible as explained by GOSBA for various reasons. So I don't think there's an objection to taking it out. But there is an interest in trying to find some sort of common ground on creating that incentive, because it has been a struggle in the past to create these mentorship programs.
And
And
you say the Senate is very interested in it and working on it.
Yep.
Okay. I think we can discuss that with them at a later time.
Yep.
Delegate Rosenberg.
Delegate Hill. I'm sorry, Delegate Hill, and then.
Yeah, well,
Mike.
go ahead. I was going to make a motion.
Okay.
Okay, I have no interest in that language. I wanted to back up to the first part that Lindsay
Hold on a
spoke
sec.
about.
Hold on, Mike. Delegate Hill, is your motion dealing with that language or the bill as a whole? Well,
It
we're
was
not,
gonna
go
be-
ahead.
Right.
Which is it?
It was to move, yeah, it can wait till after these comments.
Okay, thank you. Sure. Mike,
Thank you, sir. Back up to the paragraph that's included there. I guess I'm not sure what the intent of that is. I'm not sure including all that information in the RFP or IFB, the procurement document. My concern is the unintended consequence would be that potential bidders would only look at that information and not dig any deeper. The procurement review groups that develop this information and use it to set reasonable and appropriate goals don't know everything about the industry many times. So I think it would be good information to have. I'm just not sure how it helps the contractors achieve a goal that's been established.
I can address that.
sure,
Okay.
go ahead.
Our motivation. This was feedback from prime contractors in this case that indicated, and also from some MBE, mostly from prime contractors, that indicated that when they get a solicitation and it has an MBE goal, they don't know how that MBE goal was calculated. And they often find that from their experience that they struggle to find enough contractors to meet that goal, or they don't know where to look to find contractors to get to that goal. And so what we're trying to do here is just increase some transparency for the prime contractors when they get a solicitation, to understand sort of what are the types of subcontracting opportunities they should be looking for and identifying in their process, just to accelerate the process and make it easier for them. That's really the motivation.
Delegate Hill.
Yes, just for clarification, although we've sort of been going stepwise, I was going to move, or I am going to move that we accept all of the language recommendations that have had consensus, leaving out the issue of an appeals process, which is yet to be determined, and better language on the ombudsman role and authority.
Council, does that adequately cover the issues that are unresolved?
We are also going to update the language on the industry type, rather than having the goals by industry type, have that in the reporting.
I thought we were moving that to another section. and that
Yes,
was
that's what I
agreed-
mean by updated.
Right, but that's been agreed to, so we can, oh, I see, you're saying we should see the language before we.
Yeah.
we go
I'm
to
just
the-
referencing that that's a change to the amendments before you.
Okay. Is there any discussion on Delegate Hill's motion? Is there a second?
Second.
All those in favor, please raise your hand the old-fashioned way. Okay, there is any objection. Anyone who wishes to vote no? Okay, so thank you, Delegate Hill. We'll finish this hopefully next time. Okay, we need to recall Delegate Corman from budget considerations because the next bill is his.
Would you like me to start
Mr.
explaining?
Swit, are you from Delegate Corman's office?
Yes, I'm here. The delegate had to go over to another hearing.
Understood. All right, council, can you explain House Bill 375?
This bill repeals exemptions from the Open Meetings Act requirements for specified independent and regional development units. These are the Maryland Economic Development Corporation, the Maryland Agricultural and Resource-Based Industry Development Corporation, Maryland Clean Energy Center, and Bainbridge Development Corporation. It also recodifies existing enhanced open meetings requirements that apply to specified public bodies and expands the application of enhanced open meetings requirements to include the Board of Directors of BDC, Marbidco, MCEC, and Medco, which I just listed, the Maryland Environmental Service, the Board of Trustees of the Maryland Automobile Insurance Fund, the Canal Place Preservation and Development Authority, and the Maryland Food Center Authority, the Maryland Health and Higher Educational Facilities Authority, Maryland Industrial Development Financing Authority, and the Northeast Maryland Waste Disposal Authority. So these differences, when I refer to enhanced requirements, are the requirement to post agendas 48 hours in advance of a meeting instead of generally 24 hours in advance under the Open Meetings Act, to post minutes within 2 business days instead of, if practicable, under the Open Meetings Act now and with no particular time limit, a requirement to record the meetings in addition to taking minutes, generally under the Open Meetings Act. If you record a meeting, you do not have the requirement to also take minutes. The requirement to post the recording instead of, again, now under the Open Meetings Act, that is if it's practicable. And a change in the bill from current laws that the Transportation Authority recording under this bill is only required to be retained for 1 year as opposed to 5 years under current law. Delegate Corman has submitted several amendments to this bill. I did circulate one reprint to the bill, which was incorporating 2 amendments that he had submitted that established that project site visits and educational field tours are not meetings subject under the Open Meetings Act for the entities covered in the bill, and strike provisions from the bill that would have included the Board of Trustees of the Maryland Automobile Insurance Fund. Would you like to take that one first?
What is the committee prepared to
Move the amendment. Yeah.
move on these amendments? Well, there is a motion to do that. So which amendment are you moving, Delegate Hill?
Move the Corman amendment excluding site visits and removing the automobile.
Okay. Yeah.
Second.
So there is a second. Is there discussion? All those in favor say aye.
Aye.
All those opposed say nay. Motion is adopted. Okay, next amendment. The amendment is adopted.
Move the Kagan Senate amendment for discussion.
The next amendment that I was going to get to, I did circulate also a marked up copy of Senate Bill 269, which is the cross file. Delegate Corman had requested this amendment. It has now been finalized. So we have that before us as well, but the marked up copy just clarifies the information that is going to be publicly available by each of these public bodies on their website. It requires that the public body post each open meeting agenda together with a summary of any finalized documents, written testimony from the public, and other materials that the public body will vote on at the open meeting. It repeals language relating to, it moves language that's in current law to the language that appears in the bill. And then it also adds a special section establishing the intent of the General Assembly that the requirements for publication of documents, testimony from the public, and other materials in advance of an open meeting may not be construed to limit the discussions and deliberations of the public body.
What does that mean? Do we know what the purpose is of that uncodified language? Of that
No,
section two?
Rubin's language, office can speak to that intent.
Can you repeat the question, Mr. Chair?
Sure, sure. What is the effect of this section 2 language?
So I believe, I'm not sure. I think that was a
Speak to it.
legal thing at the top of my head. I'm gonna have to check with Delegate Corman. I'm not sure. I think that was put in by the drafter.
Mr. Chair, I think I can speak to it.
Yeah, Delegate Hill.
Okay, Delegate Hill.
I think the idea is that as these different groups, or 17 of them, however, get pulled into the Open Meetings Act, that it's to be clear that they are not, that if there is a reason that the discussion needs to go in the public meeting, needs to go beyond what's on the agenda in an unplanned fashion, unpremeditated fashion, that there's nothing in this that should limit them from being able to do that. It's just making sure that they don't, have to be stuck to sticking exactly to the agenda.
Well, I think a phrase making that clear would be helpful.
Well, that's what it says. It says, Lindsay summarized it, but what it actually says at the very bottom of what was sent over from the Senator Kagan bill is, be it further enacted that it is the intent of the General Assembly of Maryland that the requirement for publication of documents, testimony from the public, and other materials in advance of an open meeting shall not be construed to limit the discussions and deliberations of the public body. So the requirement that you pre-publish does not mean that you're limited to what you published.
Well, I would suggest perhaps that we add after public body to those items listed in the published documents and the published materials to make, I think, clearer than it is now.
Second, I don't think it hurts, right? Second it.
Delegate Saliga, do you want to speak to this or something else?
Yes, I do. Thank you.
Sure.
Yeah, I think this is really important that we don't tie their hands, that they can't talk about things that come up because we're asking them to post 48 hours in advance. And, so if there is something that comes up the day before, and you look at our deliberative body here and all the work we're doing, we certainly wouldn't want to be limited to only discussing things that the public had 48 hours notice. Obviously, we don't want it to become a loophole, but at some point we have to trust that these bodies are doing the right thing. So I think that's important. And Delegate Rosenberg, if you think that additional language is necessary, let's put it in there. But
Okay.
I'm glad to see this handwritten amendment at the end of Senator Kagan's bill.
Okay. I think I can work on that with council.
Yeah, I would just point out that if we accept this language as it's amended in the Senate, then the bills are aligned. And if we add that additional.
We have plenty of time.
Okay.
We have plenty of time. Further discussion? Is there
Do you want
a motion?
dated amendment?
Can I, Mr. Chair?
Certainly.
So one thing we noticed, when the latest amendment that was passed on 753121, it incorrectly eliminated the meeting minutes from that section. And we were submitting an updated amendment that will specify that they have to provide a draft of meeting minutes from the previous meeting.
Is the committee okay with that?
I will note that if you look at the subsection E of the next page, it does require the public body to maintain on its website meeting minutes made available under subsection B for a minimum of 5 years after the date of the meeting.
Mm-hmm.
So the requirement is already captured in the bill.
Okay. If you think that we're covered under that, I think that would be good. I think the reason that it was brought to us by some of the agencies that some of the meeting minutes are not approved until like the following meeting. And so they can't post finalized meeting minutes within that time period. So if they're allowed to post a draft of the meeting minutes before it's approved, that would give them more flexibility. So I think that's what we were going for, but then we accidentally, when we sent it over to drafting it, it was a mix up and it got deleted, that section about the meeting minutes.
Council, didn't that come up on another bill? We provided some flexibility on meeting minutes.
The bill that you're thinking of, and I do want to note to everybody that the bill hearings were supposed to start 5 minutes ago for the full committee. But that bill that you're thinking of was posting the meeting minutes online. And we adopted an amendment to change that to the finalized meeting minutes because the committee noted that the minutes might not be available. So you can't say to within 2 days.
Should we use the same language
finalized.
here?
Mr. Chair, I think it's a little different because they're talking about it in advance. You would put let's say we're meeting today, we would put the draft minutes up. And then after the meeting, and we've approved final minutes, they would go up. So there's a process for doing both, and it's the final minutes that need to be up for 5 years.
But if we don't
They want
require
it, but
two
they want
sets
the-
of minutes to be posted in the other circumstance, why should we be requiring 2 sets of minutes to be posted here?
I think it's because they think there should be minutes of the previous. When you're thinking about the agenda, the public should be able to see what was discussed at the last meeting. So where are we picking up? So even if those are unapproved draft minutes, it still gives the public a sense before the meeting starts of where the body is. I think that was the.
Well, I think we should be treating all minutes the same. What is the will of the group? Is there a motion?
You just
of any
said
kind?
makes sense to me about treating all minutes the same.
I agree. It's consistency.
I agree with that.
All right. So therefore, I will see there is a majority who support consistency in the minutes, and that language will be drafted, council.
Can
or
I
do you need
clarify
first?
what it is that you would like
Yeah.
to have changed? So right now in the bill, it says that the public body shall make publicly available on its website meeting minutes from the portions of a meeting that were held in open session, not more than 2 business days after the minutes are approved. So I think that language does track what you adopted on the other bill. I look back at the specific language from the other bill to make sure that it's exactly
Okay,
the same. But is there some other change that you're proposing to make to this bill?
we just want it to be consistent with the other bill. There's no objection to that? Okay. Is there a motion? Do we have to adopt any more amendments? Or
I
council?
don't believe that you actually voted on this second amendment from Delegate Corman, the change with the intent of the General Assembly language.
Okay, subject to some minor editing by myself and you. Okay, is there a motion on that, on the section 2 uncodified language?
We moved it for discussion, so it's already been moved and seconded.
Second, oh,
Okay, there is no further discussion on the amendment. All those in
Aye.
favor?
Aye.
Aye.
All those opposed? It is unanimous. Motion on the bill is amended. Is there a motion on the bill as amended?
So moved.
So moved.
Second.
Okay, all those in favor, please raise your hand, since this is on the bill itself as amended. All those opposed? Okay, bill has passed as amended. There is no further business, is that correct, council?
Yes, and I will circulate the updated version of the amendments on this bill.
The bill is interlineated with all the amendments.
Yep.
Fine. Okay, and you and I will talk about the uncodified language. Thank you. Okay, we are done. You can all go to the next Zoom, the full committee. Thank you.